the Trump administration's decision to impose sanctions on judges and prosecutors of the International Criminal Court, ICC, in 2025 is not merely an attack on a global institution. It is a stark reflection of the hypocrisy and duplicity that have long characterized U.S. foreign policy. By sanctioning judicial officials for investigating alleged war crimes committed by American and Israeli citizens, the United States presents itself as a champion of global justice, while simultaneously undermining the very principles it claims to uphold. This contradiction is not new. Historically, the United States has supported international justice when it serves its interests, as seen in the Nuremberg trials against Nazi leaders in 1945, while shielding its own citizens from similar scrutiny, as evidenced by its rejection of ICC investigations into actions in Vietnam during the 1970s.
Today, this two-faced approach is manifest in the United States' endorsement of ICC arrest warrants against adversaries like Vladimir Putin in 2023, while sanctioning judges who investigate allies like Israel or U.S. personnel in Afghanistan. This video examines Trump's sanctions as a case study of this hypocrisy, analyzing their impact on judicial independence, international justice, and the United States' global credibility, and argues that such actions not only weaken the rule of law, but also expose a moral inconsistency that threatens the international order.
An extensive critique of the Trump administration's sanctions on International Criminal Court judges. The decision by the Trump administration to impose sanctions on judges and prosecutors of the International Criminal Court, ICC, represents a profound and controversial intervention in the realm of international justice. Announced in February 2025 and expanded in August 2025, these sanctions target ICC personnel involved in investigations into alleged war crimes by U.S. and Israeli nationals. This essay provides an extensive critique of these sanctions, examining their rationale, legal and ethical implications, geopolitical consequences, and their impact on the principles of judicial independence and global accountability. By incorporating additional context, historical precedents, and detailed analysis, this essay argues that the sanctions undermine the rule of law, weaken international justice mechanisms, and expose contradictions in U.S. foreign policy. Background and context. The ICC, established under the Rome Statute in 2002, is an international tribunal tasked with prosecuting individuals for the most serious crimes under international law: genocide, war crimes, crimes against humanity, and aggression. With 125 member states, the ICC operates independently to ensure accountability for atrocities, particularly in regions where national judicial systems are unable or unwilling to act. The United States, however, is not a party to the Rome Statute, having unsigned it in 2002 under the George W. Bush administration. This decision reflects long-standing U.S. concerns about the ICC's potential jurisdiction over American nationals, particularly military personnel. The Trump administration's sanctions stem from two ICC investigations that have provoked U.S. ire, one into alleged war crimes by U.S. personnel in Afghanistan and another into actions by Israeli officials in Palestine. On February 13, 2025, President Donald Trump issued Executive Order 14203, authorizing sanctions against ICC officials involved in these probes. The initial sanctions, announced by Secretary of State Marco Rubio on June 5, 2025, targeted four ICC judges: Solomy Balungi Bossa, Uganda; Luz del Carmen Ibáñez Carranza, Peru; Reine Adelaide Sophie Alapini-Gansou, Benin; and Beti Hohler, Slovenia, for their roles in authorizing the Afghanistan investigation and issuing arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. A second round of sanctions on August 20, 2025, extended to judges Nicolas Yann Guillou, France, and Kimberly Prost, Canada, as well as prosecutors Nazhat Shameem Khan, Fiji, and Mame Mandiaye Niang, Senegal, for their involvement in these cases. These sanctions include asset freezes, travel bans, and restrictions on financial transactions, effectively isolating the targeted individuals from the global financial system. The U.S. justifies these measures by arguing that the ICC's actions infringe on American and Israeli sovereignty, labeling the court a national security threat and an instrument of lawfare. Rationale for the sanctions. The Trump administration's primary justification for the sanctions is the ICC's perceived overreach in investigating non-member states. The US argues that, as a non-signatory to the Rome Statute, it is not subject to the ICC's jurisdiction. Similarly, Israel, also a non-member, rejects the court's authority to investigate its actions in Palestine, a state party to the ICC. The administration contends that the ICC's investigations are politically motivated, particularly in equating Israeli actions in Gaza with those of Hamas, as evidenced by the simultaneous issuance of arrest warrants for Netanyahu, Gallant, and Hamas leader Yahya Sinwar in May 2024. The sanctions align with the American Servicemembers Protection Act, ASPA, of 2002, often referred to as the Hague Invasion Act, which authorizes the U.S. to take measures to protect its personnel from ICC prosecution, including economic sanctions and, in extreme cases, military action. The Trump administration frames the sanctions as a defense of national sovereignty and a means to protect American and Israeli personnel from what it deems baseless prosecutions. Additionally, the sanctions reflect a broader skepticism of multilateral institutions, a hallmark of Trump's foreign policy. The administration views the ICC as an unaccountable body that undermines U.S. interests, echoing criticisms from conservative think tanks like the Heritage Foundation, which argue that the ICC's actions threaten American exceptionalism. Critique of the sanctions. Assault on judicial independence. Sanctioning judges for performing their judicial duties constitutes a direct attack on the principle of judicial independence, a cornerstone of the rule of law. ICC judges, elected by the Assembly of States parties, are mandated to act impartially in upholding international law. By targeting individuals like Bossa, Ibáñez, Carranza, Alapini-Gansou, Hohler, Guillou, and Prost, the U.S. sends a chilling message. Judicial officials who rule against American or Israeli interests face personal and financial repercussions. This sets a dangerous precedent, not only for the ICC but for judicial bodies worldwide, as it normalizes the punishment of judges for their rulings. The ICC has condemned the sanctions as a flagrant attack on its independence, a sentiment echoed by international actors. UN High Commissioner for Human Rights Volker Turk described the measures as deeply corrosive to justice, while the European Union emphasized the ICC's role as a cornerstone of international justice. Historical parallels can be drawn to other instances of judicial intimidation, such as the targeting of judges in authoritarian regimes. For example, in 2018, Turkey detained and prosecuted judges who opposed government policies, undermining public trust in the judiciary. While the U.S. sanctions operate through economic rather than physical coercion, the intent to influence judicial outcomes is similarly troubling. Undermining international justice. The sanctions jeopardize the ICC's mission to deliver justice for victims of atrocities. The court's investigations in Afghanistan, Palestine, Ukraine, Sudan, Myanmar, and elsewhere address some of the world's most egregious crimes. By imposing sanctions, the U.S. impedes the ICC's ability to function, potentially deterring witnesses and victims from cooperating due to fear of retaliation. For instance, in the Afghanistan investigation, the ICC seeks to examine alleged war crimes by U.S. forces, the Taliban, and Afghan government forces. Sanctioning judges involved in this probe risks silencing victims of torture and extrajudicial killings, weakening the global fight against impunity. The sanctions also expose a double standard in U.S. foreign policy. The U.S. has supported ICC actions against adversaries, such as the 2023 arrest warrant for Russian President Vladimir Putin for war crimes in Ukraine. Yet, it vehemently opposes the court's jurisdiction when it targets American or Israeli actions. This selective engagement undermines the universality of international law and fuels accusations of hypocrisy. For example, in 2020, the Trump administration sanctioned then ICC prosecutor Fatou Bensouda for the Afghanistan investigation, a move widely criticized by human rights organizations. The 2025 sanctions escalate this approach, targeting a broader range of ICC personnel and intensifying global backlash. Legal and ethical concerns. The sanctions raise significant legal and ethical questions. In July 2025, a federal judge in Maine ruled that Executive Order 14,203 likely violates the First Amendment by restricting speech-based activities, such as those of U.S. human rights activists assisting the ICC. The American Civil Liberties Union, ACLU, and Human Rights First have challenged the sanctions, arguing that they infringe on free speech and obstruct lawful cooperation with the court. This ruling highlights the overreach of the sanctions, which extend beyond ICC officials to affect civil society actors. Ethically, targeting judges for decisions made within their official mandates is tantamount to shielding alleged perpetrators of war crimes. The ICC's Palestine investigation, for instance, examines alleged crimes by Israeli forces in Gaza, including the 2014 Operation Protective Edge and the 2018-2019 Great March of Return protests. Sanctioning judges for authorizing this probe prioritizes political alliances over accountability, undermining the moral imperative to address civilian suffering. Organizations like Amnesty International have accused the U.S. of obstructing justice, arguing that the sanctions protect powerful actors at the expense of victims. Geopolitical implications. The sanctions have strained relations with U.S. allies, many of whom are ICC member states. France, Germany, the UK, and the EU have condemned the measures, with Slovenia proposing the activation of the EU's blocking statute to counter US sanctions. This statute, used previously to mitigate US sanctions on Iran, allows EU entities to ignore extraterritorial sanctions and seek compensation for losses. The diplomatic fallout risks isolating the US and undermining its soft power, as allies view the sanctions as an attack on the rules-based international order. Conversely, the sanctions have strengthened US-Israel relations. Israeli leaders, including Netanyahu, have praised the measures, with Netanyahu describing them as a stand for truth and justice. This alignment reflects shared interests in countering ICC scrutiny but alienates other international actors, including the 125 ICC member states. The sanctions also risk escalating tensions with adversaries like China and Russia, which may exploit the U.S. stance to deflect criticism of their own human rights records. Economic and practical impacts on ICC operations. The sanctions' practical effects on the ICC are significant. Asset freezes and travel bans limit judges' and prosecutors' ability to perform their duties, as they rely on international travel and financial resources to conduct investigations. For example, Prosecutor Khan, targeted in the August 2025 sanctions, oversees multiple high-profile cases, including those in Ukraine and Sudan. Restricting her access to resources hampers the ICC's ability to gather evidence and engage with stakeholders. Moreover, the sanctions create a broader chilling effect. ICC staff may hesitate to pursue cases involving powerful states, fearing personal repercussions. This undermines the court's credibility and effectiveness, potentially emboldening perpetrators of atrocities. For instance, the ICC's Sudan investigation, which examines crimes in Darfur, relies on international cooperation. U.S. sanctions may deter other states from supporting the court, weakening its ability to deliver justice. Historical precedents and comparisons. The Trump administration's sanctions are not without precedent. In 2020, the U.S. imposed similar sanctions on ICC prosecutor Bensouda and another official, Pakiso Mochachoco, for the Afghanistan investigation. These measures were repealed by the Biden administration in 2021, reflecting a temporary shift toward cooperation with the ICC. The reinstatement of sanctions in 2025 marks a return to a confrontational approach, echoing earlier U.S. efforts to undermine international institutions. For example, the U.S. withdrawal from the Paris Climate Agreement in 2017 and the Iran nuclear deal in 2018 reflect a similar rejection of multilateralism. Comparisons can also be drawn to other states' efforts to shield their nationals from international justice. In 2003, the U.S. negotiated bilateral immunity agreements with over 100 countries, ensuring that they would not surrender American citizens to the ICC. Similarly, Russia has pressured African states to withdraw from the ICC, particularly after the 2016 African Union resolution calling for a mass exodus from the court. These actions highlight a broader trend of powerful states seeking to limit the ICC's reach, with the US sanctions representing an escalation through direct targeting of judicial personnel. Counter-arguments and their limitations. Proponents of the sanctions argue that the ICC oversteps its jurisdiction by investigating non-member states. They contend that the court's actions are politically motivated, particularly in the Palestine investigation, which they view as equating Israel's defensive actions with Hamas's terrorism. The simultaneous issuance of arrest warrants for Netanyahu, Gallant, and Sinwar is cited as evidence of bias, as it appears to place democratic leaders on par with designated terrorists. Additionally, supporters argue that the sanctions are a legitimate tool to protect national sovereignty and deter the ICC from pursuing baseless investigations. The US has a history of using sanctions to influence international behavior, such as those against Iran and North Korea. The ASPA provides legal backing for these measures, reflecting congressional intent to shield American personnel from external prosecution. However, these arguments are flawed. The ICC's jurisdiction over non-member states is grounded in the Rome Statute when crimes occur on the territory of member states, such as Palestine. Dismissing the court's actions as politicized without engaging with its legal framework oversimplifies complex issues and ignores the ICC's rigorous judicial processes. Moreover, the sanctions' extraterritorial nature, targeting non-US citizens like Guillou, Prost, and Khan, raises questions about their legality under international law, as they infringe on other states' sovereignty. Alternative approaches. Rather than resorting to sanctions, the US could engage diplomatically with the ICC and its member states to address jurisdictional concerns. For example, the US could participate as an observer in the Assembly of States Parties, advocating for reforms to ensure fair and transparent investigations. This approach would align with the Biden administration's 2021 decision to lift sanctions and engage constructively with the ICC. Another option is to strengthen national accountability mechanisms. The US could demonstrate its commitment to justice by thoroughly investigating allegations of war crimes by its personnel in Afghanistan, thereby reducing the ICC's rationale for intervention. Similarly, supporting Israeli efforts to investigate alleged crimes in Palestine could mitigate the need for ICC involvement, as the court operates on the principle of complementarity, prioritizing national prosecutions. Conclusion. The Trump administration's sanctions on ICC judges and prosecutors represent a significant challenge to the principles of judicial independence, international justice, and the rule of law. By targeting individuals like Bossa, Ibáñez, Carranza, Alapini-Gansou, Hohler, Guillou, Prost, Khan, and Niang, the US undermines the ICC's ability to hold perpetrators of atrocities accountable, potentially emboldening those who commit war crimes. The sanctions expose contradictions in US foreign policy, strain relations with allies, and set a dangerous precedent for judicial intimidation. While the US has legitimate concerns about the ICC's jurisdiction over non-member states, sanctions are a counterproductive and coercive response. Diplomatic engagement, support for national accountability mechanisms, and constructive dialogue with the ICC offer a more principled path forward. The sanctions not only weaken the global fight against impunity but also diminish the US's moral authority as a proponent of justice and human rights. In an era of increasing global challenges, preserving the integrity of international institutions like the ICC is essential to ensuring accountability and upholding the rule of law.